Hello, my name is Lisa Thomas and I'm a licensed insolvency practitioner at Neville & Co. And today I'm going to talk about the 5 different options available for UK limited companies that are insolvent. The 3 formal definitions of insolvency can be found under section 123 of the Insolvency Act of 1986. And only one of these is needed to be defined as insolvent. The first is that your liabilities exceed your assets. This is known as the balance sheet test. The second is an unsatisfied statutory demand or a county court judgment. And the third is that you're unable to pay your debts as and when they fall due, and this can catch people out. A judge will decide whether the company is insolvent and should be put into liquidation. Even if you argue you can pay a debt by selling an asset, that's not good enough. It's the fact that you can't pay the debt when it's due that is the test. A debt only needs to be £750 or more for a liquidation order to be granted. Although having said that, in practice it's unlikely for a creditor to start winding up proceedings for a debt as small as £750 due to the costs involved, but they are legally entitled to do so. A limited company in financial trouble has 5 main options open to it. I'm going to talk to you about those 5 options and give you some examples. So the red line marks whether the limited company survives or not. Of the directors we meet for the first time, probably half just want to close and liquidate and walk away, and the other half want to keep going in some form. I use the 5 option guide to work out what the best option is for directors just to make sure. Sometimes directors will come to see us with one option in mind, and then we run through them, it becomes apparent that a different option is actually more suitable. And just to say, when I talk about saving the business, I don't necessarily mean saving the limited company. I mean saving the trade within the limited company. Sometimes you can keep the trade going and all the employees together by moving everything legally to a new limited company. This is known as a phoenix. So let's talk about the options in more detail. Starting with new funds, which I think is pretty obvious. Maybe the options are to look at some bank lending, but bear in mind that the bank will probably want some security, so they'll be likely to look at taking a debenture over the company, which means they've got security over the company's assets. Or perhaps they'll ask the directors to give a personal guarantee. Directors inadvertently sign guarantees quite often and don't actually realise that what that means is if things go wrong and the company is liquidated, the bank will then look to them to repay those monies personally, and it can cause personal insolvency issues for the directors. Another option is to look at injecting funds from the directors or third parties. Ideally, the directors will take some security themselves for those, and they'll need to make sure that security is in place before they lend any money, otherwise that debenture will be invalid. Perhaps look at factoring the company's debtors, but bearing in mind that the factoring company will then have security over the company's book debts. Or perhaps look at asset finance. And all of these options are all well and good. However, it is converting the unsecured debt to secured debt and could actually make the company's position worse. Moving on to a time to pay arrangement known as a TTP. In the past, this would typically apply to a company that perhaps has had a one-off hit, for example, a large bad debt. But it has a core business that makes money and it just needs some time. Of course, this is going to look very different now due to the companies that have had to reduce or cease trading for several months due to the COVID-19 lockdown. Often with a time to pay plan, that means asking HM Revenue and Customs to give the company up to 12 months to catch up with its VAT or PAYE arrears. But this will be provided the company can keep up with its current payments up to date, and that can sometimes catch a company out. It's fairly easy to secure a TTP for the first time if they've not asked HMRC for one before. In the past, other suppliers were usually okay if you asked them to let you have maybe 3 to 6 months grace. Of course, this is probably very different now because the creditors are likely to be in a similar position, having to chase debtors to secure some cash to be able to survive themselves. Most everybody's in the same boat due to the lockdown. And just to give you an example here, one company we helped with was a groundwork company, had a 5 million turnover with about 40 employees, and the director really liked buying up plant and equipment. There were significant PAYE arrears, and in the end HMRC got fed up and issued a winding up petition against the company for about £150,000. We met with the director and explained that once this petition was advertised, the company's bank account would be frozen, and effectively that would be game over for the company. We explained the reality of the situation and that he was going to lose his business if he didn't sell some plant to be able to pay the tax off. And we got HMRC to give him a 3-month time to pay plan, and he has survived. Moving on to option 2, which is company voluntary arrangements, known as CVAs. In the past, these were actually a little bit rare and hard to get off the ground fast enough. But I suspect they're now going to be extremely popular for companies once the lockdown is properly over and they need to get some breathing space to try to recover. Basically, a CVA is an extended time for the company to pay back what it can afford to its unsecured creditors over a period of up to 5 years. The debt is frozen and often interest is frozen too. Any remaining balance owed to the unsecured creditors at the end of a successful CVA is written off. Once approved, all unsecured creditors are legally bound by the CVA, and that means that they're prevented from taking any recovery proceedings against the company whilst the CVA is in place. The directors maintain control over the company, and there is no statutory investigation into their conduct by the insolvency practitioner like there is in liquidation and administration, which I'll come on to later. CVAs often fail at a later date because the company has overpromised or it never solved its fundamental problems in the first place, which caused it to become insolvent. With a CVA, the company credit rating is badly affected, so cash flow can become very hard, so no one will give them any credit. And just to give you an example, we had a marketing firm dealing with blue chip companies, and the director knew the clients wouldn't accept him being moved to another company, so he had to keep the existing limited company going. We got the CVA approved of him paying back £2,000 a month, and HMRC insisted he also paid back his overdrawn director's loan account. He made it for 3 years, but then unfortunately he hit another bad patch and ultimately went into liquidation. And sadly, that is a typical outcome of a CVA. Moving on to option 3, administration. Administration is a very fast way of protecting a company. It can take a day or even less to get protected by applying to court for a moratorium. No one can take any action against the company whilst the moratorium is in place. Unsecured creditors are not usually involved in getting the company into administration. There are 2 types of administration. The first is known as a pre-pack administration, and this is where you line a buyer up before the date of administration and agree all the terms of the sale. The company then goes into administration and you sell the assets, usually on day 1 of your appointment. Creditors tend to hate them because they find out after the event when the business has already been sold. They can be used to settle shareholder disputes, and the richest shareholder will win. A key rule is that the business has to be advertised for sale to justify the sales price, although bear in mind advertising is very limited. You really don't have very long to save the business. The second type is administration without knowing who the buyer is. We will get appointed and then use an agent to advertise the business for sale and trade the business until a buyer is found. This can be extremely expensive. And one major issue in administration is that all employee rights, including arrears of wages and redundancy, automatically transfer to the new business owner. This is known as TUPE, and this stops many sales. Just to give you one example of administration that we dealt with, which was a pre-pack. The company had been going for years and years, but in the recent years, trade hadn't been great, and the directors had been personally propping it up by injecting their own funds in order to keep it going. It had come to the point where the directors were no longer prepared to fund it, And around about the same time, HMRC had threatened to issue a winding up order against the company and force it into liquidation. We did a pre-pack sale in administration, and this saved over 30 jobs. The purchaser also paid circa £10,000 of preferred creditors, and they also honoured some events bookings which saved over £30,000 of customer deposits. Moving on to option 4, liquidation. This is where a business is closed and any staff are laid off. It's basically game over for the company. We lock up the premises and any assets are sold by an auctioneer. There are a couple of options here. If the director doesn't want to carry on, they'll just hand us the keys and we will get on with it. We'll deal with the creditors and take the pressure off the directors. The second option might be that they actually want to buy the assets back and carry on, usually in a reduced form, which we can help them with. And this is known as a phoenix, as I mentioned earlier. They will have to pay the market value of the assets. Liquidation only takes a few weeks, and there is no TUPE applying in liquidation as there is in administration. So the employee rights rarely transfer over to the new business owner, although the employees are able to claim monies back from the government scheme known as the Redundancy Payments Office. So once in liquidation, there's usually nothing to stop a director just starting another company again and doing the same thing. Now, just to give you a recent example, because I deal with lots and lots of liquidations, but one that I dealt with a few months ago, the company's only asset was a couple of vehicles. So we helped the company go into liquidation very quickly, and the director bought the vehicles back. I did allow them over 12 months to pay for it, but because they were able to claim some monies back from the Redundancy Payments Office for their redundancy, they were able to use the redundancy monies to pay for the assets a bit quicker, and were able to therefore close the liquidation a lot sooner. And finally, the last option is striking off, also known as dissolution. It only costs £10, company's house fee, but you have to take care. It's only really to be used for a defunct company that is no longer trading and only has a minimal amount of creditors. HMRC will often lodge an objection if there are tax returns outstanding, but that tends to be academic, although it might prompt them to liquidate the company. After 3 months, the company will be struck off the register and will no longer exist. The directors need to carefully follow the rules explained on Form DS01. They have to notify all creditors, employees, shareholders, pension managers and other directors of their application to strike off. They only have 7 days. Failure can be a criminal offence. Bear in mind the company can be reinstated, so there could be some risk if the directors actually allow the company to be struck off when that wasn't the right procedure. One last thing to note is investigation. In liquidation administration, the insolvency practitioner has a duty to investigate the director's conduct, and they can be pursued personally if there has been any wrongdoing. Directors are often worried about being accused of wrongful trading or being banned from being a director. The best evidence of wrongful trading by a director is unpaid county court judgments. If a client starts stacking up unpaid CCJs and statutory demands, they are leaving a trail of evidence, and if they keep going, they are going to keep having problems and probably face a director's ban and maybe a fine. Wrongful trading claims have been suspended during the lockdown period. However, actually, other types of misconduct claims are easier to prove and pursue, so I think there's probably a bit of an academic exercise. See one of my other YouTube videos for more in-depth information on the investigation into directors. Well done on actually making it this far. Here are my contact details if you want to get a hold of me and ask me any question on anything I've discussed in the video today. Have a look at my other YouTube videos if you want more in-depth information on any of the matters that I've discussed.